You just posted a highly critical review online. Maybe it was about a restaurant, a contractor, a business that treated you badly. You shared your experience. You told people what you thought. And now you're staring at a cease and desist letter, or worse, a lawsuit demanding $50,000 in damages. But wait, isn't it just your opinion? The answer, under the law, is, it depends. And that distinction, between a protected opinion and an actionable defamatory statement, is one of the most misunderstood lines in all of American law. Get it right, and the First Amendment has your back. Get it wrong, and you could be on the wrong end of a lawsuit that costs you everything to defend, even if you win. This is how courts actually draw that line. Start with the basics. Defamation is a false statement of fact presented as true that damages someone's reputation. It covers both libel, written statements, and slander, spoken ones. To win a defamation case, a plaintiff generally has to prove the statement was false, that it was presented as fact rather than opinion, that it was published to others, and that it caused real harm. The critical word there is fact. While opinions are protected under the First Amendment so long as they don't imply provably false information, facts, if false, may always be actionable in a defamation lawsuit. So the question isn't just, did you say something negative? The question is, did you state something that could be proven false? That distinction was tested all the way to the Supreme Court in 1990, in a case called Milkovich versus Lorain Journal. A sports columnist in Ohio wrote a piece strongly implying that a high school wrestling coach named Michael Milkovich had lied under oath. Milkovich sued for defamation. The newspaper argued its columnist was simply expressing an opinion, and that the First Amendment protected that completely. The Supreme Court disagreed, at least in part. Statements that cannot reasonably be interpreted as stating actual facts about an individual are protected. Things like rhetorical hyperbole, imaginative expression, obvious exaggeration. But slapping the word opinion on a statement doesn't automatically protect it. An opinion can still constitute defamation if it can be reasonably interpreted to declare or imply untrue facts. An opinion with no provably false factual content is safe. An opinion that smuggles a factual accusation inside it is not. Think of it this way. Saying, "I think that restaurant has the worst food in the city," is a pure opinion. Nobody can prove it's false. Taste is subjective, and no court is going to adjudicate the city's food rankings. But saying, "I think the chef at that restaurant is skimming the register," is a different matter entirely. The word think doesn't save you. You've made an implied factual claim that theft is occurring, and that claim can be proven true or false. If it's false, you may be liable. Courts use several factors to figure out which side of the line a statement falls on. First, the specific language used. Is the statement framed in a way that a reasonable person would understand as fact or as personal assessment? Words like, "I believe," "in my opinion," or "it seemed to me" nudge toward opinion. But they're not a magic shield. Second, context. The general tenor of the piece matters enormously. A statement made in an opinion column is understood differently than the same statement in a hard news report. A review on Yelp is understood as a consumer's personal experience. A formal press release is not. Third, whether the statement is objectively verifiable. Can someone actually investigate the claim and determine whether it's true or false? If yes, it's more likely to be treated as a factual assertion. If no, it's more likely to be protected opinion. Fourth, the broader social context. Hyperbole, satire, and obvious exaggeration have long been protected. Calling a politician a crook in a political cartoon is understood as rhetoric. Claiming in a straight-faced article that the same politician embezzled specific funds on a specific date is something else entirely. So what does this mean for everyday people, reviewers, creators, ordinary citizens who share opinions online? In 2025, the owner of Hale's Black Brick, a Tampa restaurant, filed a defamation lawsuit against a blogger and veteran reviewer named Irene Eng after she posted a critical one-star review describing the spare ribs as dry and the meat quality as subpar. The lawsuit claimed damages in excess of $50,000 and alleged the review harmed the restaurant's search engine rankings. A judge dismissed the case, finding the restaurant had not substantiated its claims and that the review was directed at the general public, not at specific business relationships. Yelp added an alert to the restaurant's page warning that the business may have tried to abuse the legal system to stifle free speech. Eng won, but she still had to show up and fight. That's the practical trap. And it plays out even more painfully when the target doesn't have the resources to see it through. A Colorado man named Matt White posted a critical Yelp review of a flooring company called Footprints Floors in 2013 after a dispute over workmanship. The company sued him for defamation, claiming the review had cost them more than $600,000 in lost business. White never disputed the company was owed money. He disputed the quality of the work. The case eventually settled, but by then, White had accumulated $65,000 in legal fees, including a $15,000 settlement payment. He never lost on the merits. He just ran out of affordable options. This is the system working exactly as abusers of defamation law intend it to. The law may protect your opinion. The litigation process does not protect your bank account. There are some clear rules that help. Stick to what you can verify. If you're going to say something that sounds like a factual claim, that you were overcharged, that a product was mislabeled, that someone did something specific, make sure you can document it. Keep the receipt. Save the screenshots. The difference between "I felt deceived by their pricing" and "they charged me $40 when the menu said $25" is the difference between subjective experience and provable fact. And the provable fact, if true, protects you. Avoid implying specific misconduct you can't prove. Saying a business is shady or sketchy is vague enough to read as colorful opinion. Saying the owner is committing fraud crosses into factual territory that exposes you if you can't back it up. And understand that platform context matters. Courts have consistently recognized that consumers understand online reviews as personal assessments, not investigative journalism, but that context doesn't give you unlimited license to state false facts dressed up as feelings. The line between opinion and defamation is not a bright line. It's a judgment call that courts make by looking at language, context, verifiability, and the reasonable understanding of a reader. The First Amendment protects robust, vigorous, even blistering criticism. It does not protect false factual claims wearing the costume of personal opinion. The safest version of any review, any commentary, any critical statement you put into the world is one that is honest, specific about your own experience, and careful to distinguish what you know from what you're inferring. Courts can and do protect that. Lawyers will bill you either way. Know the difference before you post.